Good afternoon. My name is Elaine Alston, and I'm one of the attorneys with Kopenbarger and Kopenbarger. I will be presenting today's webinar, Trust Disputes and the Family Home. First, a little bit about me. I have been practicing for 37 years. I am a litigator, which means most of the matters that I handle involve the court processes in some way and form and another. A good percentage of the litigation cases I have handled involve trusts and wills. Additionally, some 32 years ago, I started actively advising landlords and some tenants, but mostly landlords, regarding their respective rights. I have tried hundreds of unlawful detainer trials and litigated numerous civil actions involving rental property and the rights of landlords and tenants. I have also handled bench trials regarding wills and trusts. The information today is going to be intended for educational purposes. It's not intended as legal advice. It is geared to a general audience. Because every matter is unique, and thus using information provided herein, please consult with your own personal attorney or us to make sure that it is exactly correct for your particular situation. Kopenbarger & Kopenbarger has a number of attorneys prepared to help our clients' various needs. We have a strong estate planning department led by Lloyd Kopenbarger, the founder of Kopenbarger & Kopenbarger since 1979. Working directly under Lloyd Kopenbarger is his son Larry and our partner Victoria Raymond and Mark Cruz. Our estate administration team consists of James Kosaroff as the lead attorney, working with Mark O'Brien and Megan Wilson. I work closely with the administration team on litigation matters that arise during the administration of trusts, as well as having some independent litigation and trust matters. We have a strong business and tax division with Catherine Grout and Sunny Borno. Their help is indispensable for those starting and operating businesses. Now, we couldn't do the work we do without our wonderful paralegals and legal assistants. Here is a recent group photo taken outside our Santa Ana office of the various attorneys and paralegals. Unfortunately, a few members of our team working outside of the area were unable to be photographed. We have 8 offices to help you. Our main office is the Santa Ana. We call that the South Coast Metro office. We have an office in Laguna Hills, California, San Jose, Temecula, Santa Cruz, Pasadena, San Diego, and Sacramento. We also actively use Zoom and Microsoft Teams to meet virtually with our clients. And we also use that for some of our court appearances when that is available and practical because it keeps costs to a minimum. Today's topics are the family home, warning signs, properties with tenants, protection strategies, and key takeaways. Let's talk about the family home. Why so many disputes? When a trust consists of real property assets, including the family home, the trustee is required to make and be sure that the property is fully insured, pay mortgage and property tax, and that it's maintained in good repair. Many trustees must balance fairness with legal obligations. Now let's talk about the family home. It is usually the most valuable asset in the trust. And if the home is here in California, over the years, the homes have skyrocketed in price. So a home purchased for maybe $87,000, maybe $105,000 back in 1980, 1990 timeframe is worth millions of dollars at this point. Often these homes have no debt attached to them. There is, with the family home, there is a very much an emotional attachment that many beneficiaries and trustees have towards the home. Some beneficiaries are more attached than others. A lot of times it involves the memories that are wrapped up in the home. Sometimes there's still the personal property in the home, that there's a concern about the personal property. So there's this emotional tie that must be considered by trustees in dealing with beneficiaries related to the family home. Disagreements can quickly escalate to legal matters when you're dealing with the home. So one of the things a trustee needs to try to do is to de-escalate disputes. How to do that? Well, talk to the beneficiaries, discuss possible options, let everybody express their wants, desires, and concerns. It doesn't mean that the trustee has to accommodate everyone, but if people have had their chance to say what they want, what they believe should be done, at least then they will feel heard, and that can de-escalate issues. Trustees must balance fairness with legal obligations. Legal obligations may prevent a trustee from pleasing one or more beneficiaries. Poor communication often fuels mistrust and leads to litigation. Litigation is much more likely if the beneficiaries are kept in the dark. Litigation is much more likely if the beneficiaries' desires are ignored without an explanation. Trustees' legal duties. The trustee has a duty to follow the terms of the trust and applicable state law. State law will preempt the trust provisions. The trust may have specific instructions relating to the real property, i.e. the family home. Some trusts provide that a certain beneficiary may occupy the home and may provide a specific set of instructions, such as the amount of rent that beneficiaries should pay, whether the trust or the beneficiary bears the responsibility for costs and repairs. It may discuss the responsibility to pay property taxes, etc. The trustee needs to look at the specific instructions regarding the home. One of the things is, does the trust provide that a family home is to be given to a specific beneficiary or beneficiaries? Does the trust provide the home is to be sold and dictate where the proceeds may go? A trustee cannot arbitrarily deviate from trust requirements. If the trustee wants to deviate from the trust requirements, it will require written approval of all the beneficiaries, and it may require that the trustee seeks court approval of such changes. Sometimes the trust provides for a life estate by somebody lives in the home to the end of their life. Sometimes there's a specific period of time. Again, looking carefully at the trust provisions relating to the home is important. The trustee must act in the best interest of all beneficiaries. The trustee cannot put the one beneficiary's interests above the others. In other words, the trustee, without specific instructions from the trust itself, cannot allow one person to live on the home rent-free. It cannot allow one person to use the home as a vacation destination unless it's going to allow all the other beneficiaries to use the home. It is very important with fairness and impartiality. Making sure that all the beneficiaries are given the same information is extremely important. Beneficiaries are much more likely to be upset if they find out that another beneficiary has been provided with records or documents that were not provided to them. So be sure as a trustee, make sure that all information is given to all trustees, all the beneficiaries, and that all the beneficiaries are treated exactly the same. Easy to copy everybody on the same email as opposed to sending out separate emails. A trustee also must manage the property responsibly. That means the taxes, insurance, and maintenance must be taken care of. The trustees must provide clear, timely accounting of decisions and finances. The law requires that a trustee provide a yearly accounting. Some trusts will waive the accounting. However, if a beneficiary was to ask the court will require the trustee to provide an accounting. We have one question, and this is the trust the people created the trust? Generally what happens is you have a settlor who is the person that creates the trust. Initially, most settlors become the trustees, but over time, the trust document will provide for a successor trustee. So often when the initial settlers and the creators of the trust, when they pass, there's usually a successor trustee, and often the trust has instructions as to what is to happen when the actual settlers pass. And that is the time period that I'm mostly talking about today. The trustee must avoid conflicts of interest or self-dealing. And that, now we're going to talk. What happens when the beneficiaries disagree? There's several options that occur. You can sell the home and divide the proceeds among the beneficiaries. A trustee needs to make sure that the home is being sold for its full value. I recommend obtaining an appraisal, or at the very least, a market assessment from a qualified person, a person such as a real estate broker who deals in the specific residential area that the home is located, may well be able to give a very fair evaluation of the home's value and the amount that it could sell for. There's the other option of renting the property for ongoing income distribution. Again, the rent must be a fair market rent. And the trustee must be very, very careful to follow all landlord-tenant law to avoid third-party lawsuits. Make sure that all costs, such as the maintenance, insurance, property taxes, and mortgage, are considered when determining whether or not the home can be rented and rented for a profit, so that there is an ongoing rental distribution. One of the disputes that comes about when a home is being rented out is whether or not there's a balance between what is kept in reserve by the trustee and what is distributed to the beneficiaries. If the trustee wants to keep all the funds in a reserve in case something needs to happen with the house, often there is a dispute with the beneficiaries because they see they're receiving no value for the home being in the trust. There is also the possibility of allowing one or more than one beneficiary buying the others out. Again, the trustee must make sure that the sales price is the fair market value. A trustee can allow beneficiaries to swap interests in various assets so that one beneficiary can purchase the home. But the trustee should make sure transactions are in writing and signed by all the beneficiaries, and if there's any doubt, should seek court approval. I see that we have a question from one of our participants, and it says, what about you only get a dollar clause to prevent challenges to the trust that was included in the trust language? Well, that's what we call the anti-contract provision, or an interim clause. And essentially, those clauses provide that a person will be cut out if they challenge the trust. However, challenging the trust and challenging what the trustee is doing are two different things. If you wanted to challenge the trust, saying that the trust, the settlers, when they created it, were functioning under undue influence by somebody, or they didn't have the legal capacity to enter into the trust agreement, that is a challenge to the trust. However, if the dispute is that the trustee is not following the trust provisions, or that the trustee is mismanaging, that is not a type of challenge that invokes the anti-contest provisions. When we talk about another beneficiary buying a beneficiary out, we want to make sure that those transactions are in writing, and if necessary, get a court approval for them. There is also the possibility of doing a co-ownership agreement with the home with regard to people. Now, if there is a big dispute, it would be best if you could find a mediator as an alternative to litigation. Mediation is much cheaper. You can result in everybody with an agreement and liking what the results. Court intervention should be the last resort. And in a court intervention, there's generally a winner and a loser, as opposed to mediation, when perhaps the needs of each person can be addressed. Now let's talk about spotting the warning signs and how to catch them before they escalate. A breakdown in communication between the trustees and beneficiaries is a very clear warning sign. So as a trustee, don't let emails go unanswered. A trustee should be proactive by sending out reports and information on a regular basis. A trustee should meet with the beneficiaries, either in person, Zoom, telephone. I recommend at least Zoom. That usually helps people understand what's going on. And we discussed this slightly before, but provide clear and timely accounting and finances. Avoid conflicts of self-interesting or self-dealing. Be very careful to avoid even the appearance of self-dealing. Selling the home and taking a commission would be one of those incidences. Selling the home and expecting to get a referral fee would be a problem. Living in the home and using the home personally is often something that builds tension. What are some of the things that can come up about issues is disagreements about property value or upkeep. Spending money on upkeep is often a nasty issue. You have to balance the issue of keeping the property in good condition versus spending money that's unnecessary. There's an issue of improving the property to obtain a higher sales value. You have to be careful on improvements that don't bring up value. For instance, a home with a swimming pool will sell for a little more than a home without a swimming pool. However, to the cost of putting in a swimming pool is a lot more than what would be this increase in sales value for a home having a pool. So again, it's watching the improvements as being done to maximize the sale price, but not to spend money on things that won't bring up the sales price. When a trustee sells a home that's in a trust, the trustee warrants that to the buyer that the home does not have any defects and that it's in good condition. If there is a breach of that warranty, the trust, i.e., and the trustee, can be sued. This is very different from a house that's in probate. In probate, the house is deemed to be not the property of the executor or the administrator. It's the property of the estate, and the administrator and or executor is allowed to sell the house as is, meaning that there can't be any lawsuits that come back. Probate sales are monitored by the court. Often there's a procedure whereby overbidders can appear in court to buy the home. That is not true in a trust. When a trust sells a piece of property, that is done outside of the court. Beneficiaries will have a problem if they feel they're being excluded from decision making. If the beneficiaries see that the home is falling apart and thus the value decreasing, that will upset them and they will want to talk to the trustee. If beneficiaries are seeing that money is being spent on the home that they don't think can be recouped in a sale, they're going to have issues. So the best bet for a trustee to avoid some of this is to discuss these problems with the beneficiaries. A trustee does not have to do what the beneficiaries ask, but it is much better for tension issues to listen and to explain to the beneficiaries why a different decision is being made. Now, one of the very big issues is the accounting issue, and I can't say it enough. Generally, accountings are required yearly. Now, as we talked about, some trusts waive accountings, but the court will order an accounting regardless of what the trust says if a beneficiary so asks. California law has a very rigid and awkward accounting process. You hear words like code compliant, which means that it has to follow that rigid process. Some courts and specific judges have their own rigid rules that they apply in addition to what the general law requires. If you're having to go through the court process, you will have to do the court code compliant accounting. But if you're just dealing with the beneficiaries, often the beneficiaries are willing to take an informal accounting. So it's much easier to give the beneficiaries an informal accounting when they ask for it versus waiting for the beneficiaries to make a demand in court and then having to prepare a code compliant report. An informal accounting. Beneficiaries will often accept bank statements, rent receipts, copies of maintenance logs, appraisals. That may be enough to satisfy most beneficiaries that money is not being siphoned off and what is happening with respect to the trust property. Suspicion of favoritism or financial mismanagement is another issue that comes about. Again, that can be avoided by making sure that everybody's copied on the same email. Nobody's getting to use the house more than another, unless the trust documents state that they can do so. Now, there is a risk to the trustee of personal liability if the trustee violates any of their duties, and the trustee can be held liable for losses and damages. So what should a trustee do to make sure the trust is not breaching the fiduciary's duties so as to avoid personal liability? The trustee should seek legal and financial advice. The trustee should document every decision, including the facts and the reasons a specific decision was made. The trustee should try to avoid conflicts of interest. They should remain neutral and avoid benefiting themselves. Keep clear records, detailed financial records. Keep detailed records of your communications, records between trustee and tenant, and trustee beneficiary, and trustee and advisors, so that if there's a dispute, the trustee can show why certain actions were taken. And it's important to note that when tensions exist between the trustee and the beneficiary, that's when litigation gets involved. And that is something, if you hear threats about somebody wanting to litigate, the trustee should go to counsel and talk to counsel, because perhaps there's something simple that the trustee is doing that is improper, but it can be fixed to avoid litigation. Litigation is expensive for both the trustee and for the beneficiaries, and it depletes the trust assets. There are some questions that have been asked. And what I'm going to do is I'm going to handle the questions at the end of this webinar so that we can proceed. Often when a trustee takes over property, they have tenants in the property. And what has to be done? Well, with a trust, if there's a tenant in the property, that lease remains legal and binding. In probate, where a person dies and they only have a will, or they don't have a will, there's an executor being appointed if there's a will, there's a special administrator appointed if they don't have a will. The law deems that when a person dies and does not have a trust, when it's just a person dying and they're the person holding the property, that the lease terminates with their death, and therefore in probate, all the tenancies end, and the executor or special administrator has to go through the process with respect to ending the tenancy. However, with a trust, the new trustee just steps in and takes over from the original trustee. So in other words, the trust is still there. So because the trust is still there, the rental agreements are still legal and binding, and the trustee must honor them. State law for landlord and tenant law overrides personal preference or the trust terms. In other words, and it doesn't matter if the trust says the tenancy must end when the last settler dies, such statement must be in the rental agreement. It does not matter if the trust says the property can't be rented to people with children. State law with respect to discrimination applies. So again, what you're looking for is to make sure as a trustee that you know what your landlord tenant rights are and that you follow the requirements of the trust to the extent they don't violate state law. Basically, what happens when the original settlers die, acting as trustees, a trustee and by extension, the beneficiaries become landlords overnight. I like to advise trustees when they become the trustee of a trust that has real property, which would include the family home, that as soon as they become trustee, they should do the following. Make sure that the real property is entitled in their name as trustee. Look at the trust to see if there's special instructions relating to the property. Review documents relating to the property, such as mortgages, loans, property taxes, and make sure all those are being satisfied. If there's a reverse mortgage, make sure that you understand the terms of the reverse mortgage to prevent the mortgage company from being able to take the home. Make sure that the home is insured. Review any lease or rental agreement in existence for the home. Physically examine the home. Remember, if there's a current tenant, notice will have to be given for the physical entry of the property. During the physical inspection, take photographs. Document the condition of the property, the good, the bad, the ugly. Determine if people in the real property have valid rental agreements. Determine if there are any habitability issues in the residential property. Determine whether the property is in a rent control area. Determine if the trust is currently receiving fair market rent for the premises. Determine when the last rent increase was given. If you're unfamiliar with California landlord-tenant law, consult an attorney regarding the rights, because they are can be very punitive if you don't know the rights. A new trustee must communicate with the tenants. They need to tell the tenant their name, the telephone number, and address. It can be a business address. They need to be able to know who to contact in an emergency. Make sure that the tenants know where to deliver their rent. Make sure they know who to contact if there's repairs that need to be made. A trustee needs to understand the laws with regard to entering a tenant's property. If there's immediate danger, you can enter at any time, but it must be an immediate danger, like a flood, fire, smoke's pouring out of the windows, or there's flood, there's water running in and out, there's a gas leak. Otherwise, 24 hours must be given. And if it's going to be mailed to the tenant, then it's 6 days. Trustees are considered landlords and required to abide by all the laws regarding landlord-tenant. Ignorance is no excuse. If you don't know the law, you have to talk to an attorney. You can start and take a look at the Civil Code section 1940, and it's called hiring of real property. Now, our firm has done several webinars which go into much more depth regarding landlord and tenant issues. You are welcome to view those on the YouTube channel. They may answer your specific questions. I'm trying here to present just a big overview. Trustees need to educate themselves on what the law requires for residential dwellings to be considered habitable. If there's a broken window, the home is not habitable. You can't collect rent. You have to have locks on the door. If there's no heat, that's regarded as uninhabitable. That is not the same as air conditioning. Well, some of us would think that the home would be unoccupable if it's not air conditioned, but at the moment that isn't part of the law. You have to have hot water. That is a habitability issue. Proper notice and procedures are required for evictions and rent adjustments. State law now governs all rent increases. In 2019, the California legislature passed a bill known as AB 1482, which was essentially a statewide rent control. It did two major things, and it will expire in January 2030 if it's not extended. And what it did is it said that it limits annual rent increases to no more than 5% plus local CPI or 10%, whichever is lower. CPI refers to the Consumer Price Index, which reflects the inflation rate. So basically, you're not going to be able to raise the rent more than 10%. The CPI and the 5% may make it lower, but in no circumstance are you going to be able to raise the rent more than 10%. So it may take a while for a trustee to bring a piece of property up to fair market value if the original trustee did not have it at that value. However, when you're establishing a rent, if you have a home that was being occupied by the settlers and now that you're going to rent it, you can rent it at fair market value, but you have to keep in mind that the rent increases that you do can't be more than what is provided by the law. The other thing that AB 1482 did was it created the just cause eviction. And there's two prongs to the just cause. One means that the tenant is at fault. They didn't pay rent or they violated one of the provisions in the rental agreement. And that requires then the giving of a 3-day notice to cure, followed by a 3-day notice to terminate, followed by an unlawful detainer complaint if they don't vacate. However, if you just want to terminate it on its terms, for instance, the lease said that it would expire in April of 2026. At that point in time, you need to inform the tenant 60 days beforehand that the lease won't be renewed and that they will be terminated at that point in time. If you decide that if the lease is just an ongoing lease or rental or a month-to-month rental agreement, if you wish to terminate somebody, there's the provisions that require how you have to do it if you just decide you don't want to rent the property anymore, for instance. You have to give the tenant 60-day notice if they've been living there for more than a year. If it's less than a year, you have to give 30 days. There is an amount that you have to give the tenant. Usually it's the 1 month's free rent. If you're trying to terminate it just because you no longer want to rent the property or that you want to renovate the property. Again, in each specific circumstances, you need to talk with an attorney, look at the law to see exactly what you have to do. But a trustee must follow the eviction laws that are set forth in what was codified for the AB 1482. Now let's talk about protection strategies and avoiding costly court battles. Here, there are things that everybody can do. First, make sure that to the extent that you're the creator of a trust, make sure that the trust language is clear about how the property is to be handled at the time of your death. I would encourage everyone to use mediation to resolve disputes. Again, mediation gives everybody a chance to have a little bit of what they want, as opposed to one big winner and one big loser. And trustees should maintain really, really good records. They should be transparent, and the trustee should be willing to provide those records to the tenants really at any time when the tenants ask. Not tenants, when beneficiaries ask. There's no real reason to try to keep a beneficiary in the dark as to what's happening with the family home, what it's costing to keep it up, what the tenants are paying, what is being done with the money that is being either brought in from the house, or what is the market value of the house, and what is being spent to try to bring the house into better condition so that a higher sales price can come about. Appraisals are one of the easiest way to get everybody on the same page as to what the home is worth. Many times children have an entirely different view of what the family home is valued. Some think it might be 1.2. Somebody else thinks that it's 2.3. The easiest way is to get in a proper appraisal, and that really will resolve disputes over the value of the home. If the estate has a lot of property, has a lot of different revolving issues, it may be that the trustee should be a professional fiduciary. Those are things that a settler can consider. It's also something that if you're appointed as trustee and you think it's beyond if your abilities or you want some help, finding a professional fiduciary may be the answer to that. Again, getting beneficiaries educated on their legal rights and duties is also helpful. And that's something a trustee can easily do by sending to the beneficiaries a list of the duties that the trustee has, and making the beneficiaries understand that that's what they're going to do. Key takeaways here: family homes carry both financial and emotional weight. Trustees and beneficiaries each have rights and obligations. And if there are tenants in the home, then tenants have legal rights that must be understood. Understanding the law helps unnecessary disputes. And again, if you hear litigation is being threatened, do as a trustee, consult with an attorney. Early planning can prevent costly litigation, i.e. making sure you've kept the right records, sending out the records so that the beneficiaries can see that will avoid a lot of litigation. Basically, knowledge is the best protection for the trust. Now, in conclusion, basically, what can we do to help you? Well, we can guide you through trust disputes. We can help you confidently manage the property that's in the trust. We can help you create clear estate plans to preserve, hopefully, family harmony. Why us? We've been here since 1979 and are going to be through hopefully another 100 years. We have 10 full-time attorneys and 1 attorney of counsel. And that means we've got about 350 years of combined knowledge. We have attorneys with advanced tax degrees. We have certified specialists in probate, estate, planning, and trust law. We've got over 45 highly qualified support staff. We've got 8 different offices plus Zoom capabilities. And we're here to help. So contact us. You can contact us by telephone number, by our website, our email. When we finish this webinar, if you would please give us a digital evaluation, that would be very much pleased. You can check the link in the chat. And now what I'm going to do is I'm going to try to go through and see if we've got some questions that need to be answered. One question here is, do you need a title lock if the property is in a trust? Title locks are a way to try to prevent people unscrupulous from stealing property, and they do so by getting and filing false documents with the records department for the various counties. It is not absolutely necessary, but it is probably a wise thing to do. The next question here is, oh, sorry, I'm having trouble finding. Let's go to the next question. What if you have in your trust that one beneficiary out of the 3 has the first right to purchase? If that's what the provision in the trust is, then if that is supposed to happen at the point in time when you as the original settler and original trustee die, then your trustee who takes over, your successor trustee, will then have to proceed to see whether or not that one beneficiary wishes to purchase the home. That trustee should make sure that they know the fair market value of the home, most likely by obtaining an appraisal. They can, as we discussed, perhaps find a real estate broker who could give a very good estimate of what the value of the house. But in anticipation of litigation from the other 2, it might be wise to have a very good appraisal so that you can make sure that you're going to sell it to the person. You give them a period of opportunity to purchase the property at that price. If they choose not to at that time, then the obligation is over. However, it is also possible where you, as a trustee, would list the property, and at that point, if somebody came to purchase the property, the beneficiary with the right of first refusal, in essence, could say, no, I want to buy the house at the price that that third party is willing to pay for it. The next question says, are there rules for revocable trust versus irrevocable trust? An irrevocable trust means that the settlers can't change and can't do away with the trust. A revocable trust means that the settler can decide that they no longer wish to have the trust and they can stop the trust. It doesn't change the rules with respect to what is going to be done with the home when it's in the trust. The only difference is that a person who is a settler, not a successor trustee, but one of the initial trustees who are the settlers, the creators of the trust, if they so choose, they can take the home out of the trust. They can terminate the trust itself, but that is not something a successor trustee can do. So there is not really any difference. There's a few other questions. One, it says, as a trustee, I sold a family home last November. All property taxes have been paid. I was then required to pay a supplemental tax in March of this year. Is that legal? Yes, it is. This one is from, what says, I've been recently instructed to not include our family home in the trust. What do you recommend? I absolutely recommend that you put the family home in the trust. There is no reason that you want the home to go through probate. Probate involves a lot of tax money going out. It involves a whole problem when selling the home. Homes that sell through probate usually get a lower amount because people know they're buying the home as is, and there's no reason why your home should do that. The next question is a trust considered confidential? If an HOA demands a copy of the trust, is the trustee required to compromise confidentiality? A trust is not particularly confidential. You may wish to keep it confidential, but there's no requirement that it be. If an HOA demands a copy of the trust, what I would suggest that you try to provide them with and satisfy their needs is a certificate of trust. And the certificate of trust will let them know that the home is in the trust and certain provisions. They don't need to know the entire successor plan that you have for the trust. Now, the next question is, generally speaking, to whom other than beneficiaries must a copy of the trust be given to by the trustees? Generally speaking, there's no one else that needs to have a full copy of the trust. A certificate of trust usually will do the work. For instance, if you're trying to insure the home and you need to show that it's in a trust, the certificate of trust should be satisfactory. And that appears to be, we have another question here. What if one of the settlers is not dead, but in care, but out of 3 children, one is taking control and making all decisions? The other 2 do not have any access to the trust. That's a very specific question that I would think that basically you need a personal consult. But what I will say is this. If one of the settlers is deceased and one now is in care and no longer has the ability to be trustee, i.e. they're lacking in capacity, then the trust provision that next says who takes over, who is the next trustee. If one of the children that's taken over is the trustee, then that's not improper. But if that is not the successor trustee, then that is improper. But again, I think with that specific question, I would suggest that you have a consult directly with an attorney on your specific situation. And now a question is asked is, can a transfer on death replace a trust? Well, there are 2 different circumstances. Certainly, if you want to have the home just transferred on death, i.e. like a joint tenancy or the like, yeah, you wouldn't have you would not then have that house in the trust if it's going to be transferred based upon its title, joint survivorship. You need to talk to your estate planner as to which one of those is the best for your financial circumstances and the beneficiaries that you have involved. That appears to be, the question now is, how do you get a certificate of trust? Have your attorney who prepared your estate plan prepare a certificate of trust. All of the packages that Kopenberger put out, we always give you a certificate of trust. But if the one was not created at the time, have your estate planning attorney prepare one. And the next question, is it recommended for all beneficiaries to have a copy of the entire trust ahead of time? Depends what you mean by ahead of time. Basically, when the settlers pass on and a new trustee a successor trustee takes over, normally a notice is sent out to all the beneficiaries, giving them 120 days to challenge the trust. And at that time, a copy of the trust is sent to them. However, you have to look at the circumstances. Maybe it is best if you have say 4 kids and they're all going to get equal and you want them to know that and you hand it out. Or perhaps maybe you do want your kids to know that you are giving a life estate to one of the children because for whatever reasons, and you have a chance to explain it. But that's an individual choice. So I wouldn't say whether it's recommended or not for our beneficiaries to have the trust ahead of time. It's one of those things that you want to think about with your own specific beneficiaries as to whether or not that would be wise. Seeing that that's all the questions, I'm going to sign out and wish you the best.